Well, good afternoon, and thank you very much. My name is Nathan Hochman. I'm the Los Angeles County District Attorney. With me up here are prosecutors who made up the Menendez team. We have Ethan Milius, Sept Carmack, and Habib Bailey, and collectively they actually bring 60 years of prosecutorial experience as part of this team that analyzed over 50,000 pages of trial transcripts from 2 months-long trials. Thousands of pages of confidential prison files for both Erik and Lyle Menendez. They were with me as I spoke for over 3 hours with the Menendez family members and heard all their thoughts and perspectives. I spoke with defense counsel, I spoke with prior prosecutors, and I spoke with investigators. And in doing that, we analyzed the 3 different courses that the Menendez brothers had sought to be released from prison. One we've already dealt with before, which is the resentencing that led to a parole hearing. The argument we made there, which we have made consistently, was not never, but not yet. In other words, that when we looked at both the resentencing issue and ultimately the parole issue, we determined that the Menendez brothers had never come fully clean with the central defense that they had articulated during trial. That's the self-defense defense. That they said, in essence, that the reason they killed their parents is they believed their parents were going to kill them first the night of August 20th, 1989, so they had to brutally shotgun them to death in order to make sure that didn't happen. We showed that was a bald-faced lie, a lie that the Menendez brothers persist in telling for the last 30 years to this day, by showing that they bought the shotguns that ultimately killed their parents 2 days ahead of time in San Diego under fake names, that they then had a pre-planned alibi set up for that particular night. They were going to be going to Batman the movie and even tried to purchase Batman the movie tickets after the murders. They'd actually practiced with the shotguns the day before. And when they killed their parents, they did it methodically to look like a mafia-style hit, shooting the dad from the back of the head. The mother, who lied bleeding on the ground, they actually reloaded a shotgun and shot her at point-blank range in the cheek. And then to complete the mafia facade, they shot him in the kneecaps. Afterwards, they methodically got rid of the evidence, the shotgun shells they picked up from the floor, the shotguns and the bloody clothing that they disposed of, either in a car wash dumpster over the side of the Mulholland freeway. And then they ultimately came back to their house, called 911, and screamed, "Someone shot our parents," and never came clean with it until tapes eventually emerged months and months later. But at trial, they persisted in saying, not that they were sexually abused as the excuse for why they killed their parents. And I want to make that crystal clear. Each Menendez brother was asked during one or both trials, is the reason that you killed your parents because they sexually abused you? Answer under oath, no. So then what was the reason? Because they said our parents were going to kill us that night. Not just dad, but mom too. So we had to blow them away first. That self-defense defense, because they've never come clean with it, also coupled with their most recent violations in prison, awaiting a potential parole hearing, is why we first argued there shouldn't be a resentencing, and then we later argued that parole should not be given. The parole board eventually agreed with the positions that we took. So that was course number 1. Course number 2, which exists today, is a clemency course. And that's a course of action where they've made a direct pitch to the governor, who under the California Constitution has the unilateral power to go ahead and grant clemency and release the Menendez brothers, if he so chooses, today. Or for that matter, any day he has been in office since 2019, and any day he will continue to be in office until he eventually completes his service as governor. So that is the second course of action. Today, though, we're here on the third course that the Menendez brothers pursued, and that was a habeas corpus petition that they filed in May of 2023. What a habeas basically says is it's asking for a new trial. It says that if new evidence has come forward, new, timely, credible, admissible, compelling evidence has come forward, such that even one juror may be convinced that not beyond a reasonable doubt that you did the crime, that you can be entitled under these very limited circumstances to a new trial. So the Menendez brothers went ahead back in May of 2023, and they isolated 2 additional pieces of evidence that they said had never been previously presented at trial and met the rigorous standard of habeas review in order to get this new trial. One piece of evidence was a letter supposedly written by Erik Menendez to his cousin Andy Kano, supposedly around December 1988, about 9 months before the August 1989 murders. And the second was a declaration by Roy Rosello that said he had been sexually abused by Jose Menendez back in 1983 or 1984. What we said then, what we said in our informal opposition, what we said in our formal opposition, is that these 2 pieces of evidence didn't meet the procedural requirements to be even considered to get a new trial. Those are the procedural requirements of being, well, let's start with new. We said a letter from 1988 from Erik Menendez to Andy Kano, both of whom testified at each of the trials, and neither of whom testified that this letter and communication existed. In fact, each of them testified at the last communication they had about the sexual abuse that Erik Menendez had experienced was 6 years before 1989, when Andy Kano was 10. Erik Menendez was 12 or 13. And they had not had another communication about it since then. But lo and behold, they found this letter, supposedly after the trial, even though it was written 9 months before the trial. Erik Menendez didn't testify to this letter or its existence. Andy Kano did not testify to this letter or its existence in 2 different trials. So we argued that it didn't meet the new qualification. We said it wasn't timely. They had this letter 35 years ago. To be timely generally for a habeas petition, you have to have found stuff that was within you have to file the motion within 5 years of discovering the new evidence. At best, this letter was used during a 2015 Barbara Walters television show, and they still waited till 2023, so we said it wasn't timely. We said it wasn't credible. How can you believe this letter actually existed when nobody testified to its existence in 2 different trials? And we also said it wasn't material or significant that would lead to a new trial. What we said about the Roy Rosello declaration is we made the same arguments, that effectively it wasn't timely. It wasn't new, it wasn't credible, but especially it wasn't admissible, because the new evidence has to be admissible. But how can something that occurred back in 1983 or 1984, which each Menendez brother said they had no idea existed, how could that have influenced whether or not the Menendez brothers decided to kill their parents in a premeditated and deliberate fashion in 1989? Because at that moment, August 20th of 1989, they had no idea whatsoever about what had happened between Roy Rosello and their father, Jose Menendez. In fact, they were not to learn about this for almost 30 years later. So we said that too shows it does not meet the procedural hurdles to even get to the question of whether or not it would actually result in a new trial. So what Judge Ryan did yesterday, in agreeing with our position, our ultimate position, and ending, for now, unless they keep appealing this, the meritless motion that the Menendez brothers filed, he basically said that the evidence alleged here is not so compelling that it would have produced a reasonable doubt in the mind of at least one juror. That is how deficient, how meritless, how baseless the evidence that has been presented by the Menendez brothers has been in this habeas motion. So Judge Ryan has put a full kibosh on the habeas motion here. So now we have the resentencing/parole course has not resulted in the Menendez being released. The next parole hearing is scheduled for 3 years, although the parole board could advance it. We have the habeas petition now that is ended. The Menendezes could always appeal it if they so choose, and I trust that the appellate courts will will reach the same result that Judge Ryan has reached here and find it utterly meritless. And then there's that clemency path that the Menendezes have always had, in which the governor can grant them clemency if he so chooses any day he remains in office. So again, let me thank the prosecutors who have spent an enormous amount of time, effort, research to make sure that we got it right. And that was the goal. Let's put in the hard work to make sure we get all the facts in front of the judge so that the judge can then make a decision based on the entire record, not just some parts of the record that certain Netflix documentaries, certain parts of the social media has picked on. We laid out in over 130 pages what the entire Menendez record looks like, and Judge Ryan read our submission, relied on the record, and denied the habeas motion.